Okay. Custody, and you have to forgive me if I start to smile on this one, is kind of a dirty word in New Hampshire now. There was a movement in recent years away from the term because it was considered, again, as I said, it had become sort of a dirty word. Folks would come in, sit down in front of a lawyer, and the first thing they would say is, well, I want custody. And then you're off to the races, fighting with one side saying, I want custody, and the other side saying, I want custody, or you can't have it. So now instead, it's spoken of in terms of parenting rights and responsibilities. And as you might guess, folks come in and often sit down and say, I want primary parenting, because folks aren't dumb. They know where the issue really lies, no matter what the label. But today, we have parenting plans that set forth parenting rights and responsibilities. And I do know what someone means when they ask me still about custody. And they're probably wanting to know, how is the parenting schedule going to be set up? And what goes into a determination of what would be the right parenting schedule for this couple now as they're going their own way. And the court would necessarily consider the best interest of the children in a variety of ways, how they'll be brought up, how they'll be cared for. Probably everyone can take some real solace and some confidence, though, in knowing that there is a very strong presumption in New Hampshire, a starting point in the court's analysis, that whatever that schedule looks like, it should involve both parents being very much involved, quality time, and a lot of it in raising the children going forward. And so no longer do we have as a starting point, as we did 20 years ago and even more recently than that, the old starting point, using the terminology of custody, where a child would live in one home and the other parent would visit. Instead, now we have parenting rights and responsibilities and a presumption, a starting point on the part of the court that both parents should very much be involved in the parenting time with the child. And it would be up to someone to convince the court why that presumption shouldn't be the result in their case. Why maybe one parent should have 5 or 6 days and the other parent maybe only 1 day. And that today would be the unusual case. Whereas in the old days, maybe one parent would have all of every other weekend and maybe a couple Wednesday afternoons out of every 2-week period. Those days are gone.